We're doing something a little different today.
Oh, yeah.
Usually when we sit down to unpack a topic, our goal is clarity.
Right.
We want to find the signal in the noise.
That's the mission. Take the complex and make it simple.
Exactly. We're looking for that aha moment where everything just clicks into place. But
Not so much.
today, we're looking at a stack of documents that does the exact opposite. We're looking at a situation where the smoking gun isn't a weapon or a confession. It's a massive tangled knot of conflicting government paperwork.
It's a mess.
It really is. I mean, if you were paying attention to the news cycle in the summer of 2025, which feels like a lifetime ago now, doesn't it?
It really does.
You likely felt a profound, almost physical sense of whiplash.
I think that's putting it mildly. It wasn't just whiplash. It was a constitutional collision.
Yeah.
You had the tectonic plates of the government just slamming into each other.
That's a great way to put it. Because in July 2025, you had the United States Department of Justice and the FBI effectively walk up to a podium, dust off their hands, and say, "It's finished."
We're done here.
Yeah. They released this definitive memo declaring the Jeffrey Epstein case closed. Dead, buried, done.
And they were emphatic about it. I mean, the language was so final. They wanted to turn the page. They wanted to put the final period at the end of a very long, very ugly sentence.
But then, and this is the paradox we're unpacking today, almost immediately, practically before the ink was even dry on that memo, you have a federal judge in New York
And a congressional committee in Washington.
ripping that case closed sign right off the hinges.
It creates this fascinating tension. You have the executive branch saying, look away, it's over. And then the judicial and legislative branches saying, look closer. We are just getting started.
So that is our mission for this deep dive. We aren't just rehashing the old 2019 headlines that everyone knows.
Yeah.
We aren't, speculating on rumors.
So.
We are untangling the specific legal and political web that was spun between July and August of 2025. We're going to look at the final official words on the investigation and the fierce three-way battle over what secrets are still locked away in the dark.
And to do that properly, we have to ignore the noise. We have to ignore the Twitter threads, the Reddit forums, all the cable news pundits. We are going strictly to the primary sources.
The actual paper trail.
Whole paper trail.
So lay out the stack for us. What exactly are we dissecting today?
Okay, so we have 4 critical documents that really tell this story.
Right.
First, we've got the internal closing memo from the FBI and DOJ, dated July 2025. This is their exit interview on the case.
Their final word.
Their final word. Second, we have a dense 14-page decision and order from U.S. District Judge Richard M. Berman, dated August 20, 2025.
Okay.
Third, there's a massive sweeping subpoena from the House Oversight Committee that was issued just 5 days later on August 25th.
Things move fast. So what's the fourth?
The fourth is a bit of time travel. To really understand the legal strategy underneath all of this, specifically the fight over privacy, we're going to flash back to 2016 and look at some recently unsealed deposition transcripts from Ghislaine Maxwell.
Okay, so it sounds like a lot of heavy legal lifting, but when you line them up chronologically like that, it really does play out like a thriller.
It does.
So let's start with the Department of Justice, July 2025. The memo drops. And I remember reading the headline and thinking, okay, surely after all this time, after all the theories, all the doubts, they have to have found something new.
Right. And if you only read the press release, you might think they did a thorough job. But we're here to read the footnotes.
We're here to read the specific language they used to justify walking away.
Precisely.
So let's get into the specifics then. The memo claims to be an exhaustive review. Now, exhaustive is a strong word. What did that actually look like on paper?
Well, they cite reviewing over 300 gigabytes of data.
300 gigs.
Now, we need to contextualize that, right? In today's world of high-definition video, 300 gigs isn't that much. But in the world of text documents, spreadsheets, PDFs, emails...
Oh, it's an ocean.
It's an absolute ocean. It is millions and millions of pages.
A mountain of digital paperwork.
Exactly. But they didn't just sit at a computer terminal. The memo makes a point to specify that they conducted physical searches, and they list where they looked.
I remember this part.
It says, squad areas, locked cabinets, desks, closets, and other areas where responsive material may have been stored.
Squad areas and closets. That phrasing stuck out to me immediately. It paints this picture of agents physically, rummaging through the back offices of FBI field offices.
It does.
It implies they were looking for things that weren't supposed to be there, or maybe things that were supposed to be there and got lost.
Well, it implies they were looking for rogue evidence. They were checking to make sure some field agent back in 2008 didn't, shove a tape or a file into a shoebox in the back of a closet and just forget about it. They were trying to prove a negative, that absolutely nothing was left behind.
Okay, so they search the closets, they scour the hard drives, and they come to three major conclusions. Let's unpack them one by one. The first big headline from this memo was about the death itself. Because even in 2025, the Epstein didn't kill himself meme was still alive and well.
And the FBI clearly tried to kill that meme with this memo. They definitively reaffirmed the conclusion that Jeffrey Epstein committed suicide on August 10th, 2019.
Okay, but we've heard that before. What was new here?
Well, they went a step further than just citing the medical examiner of the autopsy. They added a new layer of technical detail regarding the surveillance that we hadn't really seen emphasized before.
You're talking about the SHU video, the special housing unit.
Correct. Now, we all know the cameras inside the cell were an issue, that whole story. But the FBI claims they conducted an independent review of the footage from the tier itself, so the hallway outside the cells.
The common area.
Exactly. And they established a very specific, verified timeline from that footage.
Walk us through that timeline. What did they say they found?
The memo states that Epstein was locked in his cell at approximately 10:04 p.m. on August 9, 2019. From that moment, until around 6:30 a.m. the next morning.
That's almost 8 hours.
Right. And the review confirmed that nobody entered any of the tiers in the SHU.
So a verified 8-hour window of total isolation, a ghost town.
According to their review of the footage, yes.
Huh?
And they noted that they even enhanced it. Increased the contrast, balanced the color to be absolutely certain. They essentially said, we watched the tape, we turned up the brightness, nobody went in, nobody came out, it was suicide.
Okay, so they locked down the death. They're saying, stop asking, the video proves it. But let's talk about his life, because the biggest question hanging over this entire saga has always been, who else?
Who else? Yeah.
Who were the clients? Who were the enablers? And this is where the memo drops a bomb that I think frustrated a lot of people.
It is a masterclass in legal drafting. I mean, if you are a lawyer, you might miss a sleight of hand here.
So what did it say?
The memo states, this systematic review revealed no incriminating client list.
Okay, stop right there. I want to drill down on that. No incriminating client list. That one adjective, incriminating, is doing a lot of heavy lifting, isn't it?
It's doing all the lifting. It is the load-bearing wall of that entire sentence.
Explain that. What does that mean in the legal terms?
Okay, so in a legal context, incriminating means evidence sufficient to prove a crime beyond a reasonable doubt. It doesn't mean no list of associates. It doesn't mean no list of people who flew on the plane.
But it doesn't mean no list of famous friends.
Not at all. It means no list that, on its face, proves a crime was committed.
So, theoretically, the FBI could be sitting on a list of 50 of the most famous people in the world who visited the island. But if the list itself doesn't explicitly say, here's the illegal act they committed,
then the DOJ can technically, and I guess truthfully, say, we found no incriminating list. Unless the list is literally titled, people I committed crimes with, it might not be considered incriminating on its face. The DOJ is essentially saying, we found names, sure, but we didn't find a list that comes with its own proof of guilt.
That feels like a distinction that matters a whole lot to a lawyer and not at all to the public.
It matters immensely to the DOJ because it justifies closing the case.
Of course.
And they go on. They say there was no credible evidence found that Epstein blackmailed prominent individuals.
Another big one.
Huge. And perhaps most significantly, especially for the conspiracy theorists, they stated they did not uncover evidence that could predicate an investigation against uncharged third parties.
Predicate an investigation. Translate that for us. What's a predicate?
In FBI terms, a predication is the factual basis you need to open an investigation. You can't just investigate someone because you have a hunch or you read something on the internet.
You need a reason.
You need a predicate, a factual starting point. So they're saying, we looked at the 300 gigs, we looked in the closets, and we don't have enough hard proof to even open a new file on anyone else.
So after all the years, all the rumors, all the connections to powerful people, the official conclusion of the U.S. government in 2025 is it was just Epstein. No blackmail, no other big names to charge.
That is their stated position. But there is a haunting statistic in this very same memo that makes that conclusion very difficult to swallow for a lot of people.
I know what you're going to say.
While they claim there is no client list and no third party to charge, the review confirmed that Epstein harmed over 1,000 victims.
1,000.
Over 1,000. The memo notes that each of them suffered unique trauma.
That number just, it stops you in your tracks. Over 1,000 victims, and the DOJ is saying, we have 1,000 victims, but we don't have a list of people they were trafficked to.
That is the disconnect. That is the central paradox of this entire memo. You have an industrial scale of victimization, 1,000 people, which implies an industrial scale of demand.
Right.
Yet the investigation concludes the demand side is somehow invisible or non-existent in the evidence they have.
How does the DOJ explain that? I mean, how do they say, we are closing the case with 1,000 victims just left in the wake?
They pivot to privacy. The DJ argues that sensitive information is intertwined with the evidence. That's the word they use, intertwined.
So they're saying they can't release the files because victims' names are in there.
Essentially, yes. They say that because victim names, their likenesses, their medical histories are all mixed in with everything else, they can't just dump the files publicly. They're using privacy as the shield.
And their final line on this?
They say, and I'm quoting here, it's the determination of the Department of Justice that no further disclosure would be appropriate or warranted.
Wow. Basically, we looked, it's bad, there are 7,000 victims, but it's over. Trust us.
And that trust us approach is exactly what triggered the next document in our stack. Because while the DOJ was trying to close the book, they made a very, very strange legal move that landed on the desk of Judge Richard Berman.
This brings us to Section 2 of our deep dive, the government versus the judge. And this is where things get really ironic.
They get weird.
Usually when we cover these legal battles, you expect the government to be the one fighting to keep things secret and, the press or the public fighting to open them up.
Right. The government almost always wants to protect its methods and sources. That's the standard line.
But here, in July and August of 2025, the roles completely flipped.
It was a bizarre procedural posture. I mean, you have the government, the DOJ, filing a motion to unseal grand jury transcripts from 2019.
From the original indictment.
From the proceedings that led to Epstein's original indictment right before he died. All of a sudden, the DOJ desperately wanted these made public.
Why? I don't get it. If they just issued a memo saying, case closed, nothing to see here, why go back 6 years and try to open up old secret grand jury testimony?
Well, Judge Berman had some thoughts on that. And he didn't hold back. In his order denying their request, he suggests it was essentially a diversion.
A diversion? A distraction from what?
A distraction from what they weren't releasing. Let's look at Judge Berman's ruling from August 20, 2025. He denied the motion to unseal, unequivocally. And he bases this on Federal Rule of Criminal Procedure 6E.
Rule 6E, okay. The sacred rule of grand juries. I feel like we need to pause and explain this because it's the hinge the whole argument swings on.
Absolutely. So, in the American legal system, the grand jury is a sacred, secret space. It's not a public trial.
Yeah.
As the judge quotes in his decision, the tradition of grand jury secrecy is older than our nation itself.
Why is it so secret? What's the point of that?
It's about freedom to speak. The whole idea is that for a grand jury to function properly, to investigate crimes freely, without fear or favor, witnesses and jurors need to know their proceedings won't be broadcast to the world on the nightly news.
So people will talk honestly.
Exactly. If a witness thinks their neighbor or their boss is going to read their testimony in the paper, they won't talk. So the rule is extremely strict. Grand jury materials stay sealed forever, unless there's a very specific special circumstance.
And the government tried to argue there was a special circumstance here.
They argued public interest. They basically said the public needs to see this to understand what happened. It will promote transparency.
And the judge wasn't buying it.
Not for a second. He pointed out a glaring, massive inconsistency in their argument. He notes that the government is sitting on what he calls a trove of Epstein documents.
A trove?
His word. Over 100,000 pages of actual investigative files, the raw material.
Wait, 100,000 pages? That sounds a lot like the 300 gigabytes from the DOJ memo.
It's the same material. And the government had just announced in their July memo that they would not be releasing those 100,000 pages.
Okay, I see where this is going.
So Judge Berman basically asks, why are you so desperate to release these 70 pages of grand jury transcripts, which are legally protected by Rule 6E, while you are actively hiding the 100,000 pages of actual evidence that you could release if you wanted to?
Ouch. He's calling their bluff. He's saying, you want to look transparent by releasing this tiny sliver of hearsay while keeping the entire mountain of real evidence locked in the bark.
Exactly. And the word hearsay is key here. The judge explicitly calls the grand jury testimony merely a hearsay snippet. And in his ruling, he reveals something that I think shocked a lot of legal observers at the time.
What's that?
Not a single victim testified before that 2019 grand jury.
Wait, are you serious? The grand jury that indicted Jeffrey Epstein? They didn't hear from a single one of his victims.
According to Judge Berman's order, no. The only witness who testified was, quote, a law enforcement FBI agent who had no direct knowledge of the facts of the case and whose testimony was mostly hearsay.
So the agent just went in and read a summary of the investigation to them.
Essentially, yes. He summarized the case for the jurors. So the judge is asking, what is the public interest in reading a transcript of an agent summarizing things we already know when the actual evidence, the victim statements, the flight logs, the raw data, is being locked away in the DOJ's basement?
That is a fascinating insight. It really does make the DOJ's motion look like a PR stunt. Look, we're unsealing something. But it's the one thing that doesn't really matter.
And there was another major factor in the judge's decision, maybe the most important one, the victims.
Right.
The court received letters from victims' rights attorneys. We're talking prominent names like Boyce Schiller and Bradley Edwards. They were vehemently opposed to unsealing this grand jury material.
Why? Because of privacy.
Yes, they argued that unsealing poses direct threats to the safety and the dignity of the victims. One of the letters that the judge quotes in his decision says, transparency cannot come at the expense of the very people whom the justice system is sworn to protect.
That's a powerful line.
It is. And the judge took this very seriously. He noted that even if you redact the names, the context, the details of the abuse, could still expose victims who haven't come forward publicly.
It's such a powerful argument. So you have the victim saying, keep it closed. You have the judge saying you have to follow the rules, and you have the DOJ saying, open it up, but only for this one specific, seemingly low-stakes document.
It just highlights this incredible tension between the public's right to know the truth and the system's duty to protect the survivors.
Yeah, and to really understand that tension, why the victims are so terrified of these details getting out, we need to pivot to the third part of our stack. We have to look at why privacy is such a weapon and a shield in this case.
That's right.
Because when we talk about privacy in the abstract, it just sounds like a legal technicality. But when you look at the actual depositions, you realize what is actually being fought over.
It becomes very real.
So we have transcripts here from 2016. This is from the defamation case against Ghislaine Maxwell. This is before she was ever criminally convicted.
And these transcripts are so illuminating because they show the modus operandi, the method of operation. And they show exactly how her defense team used the concept of privacy as a shield to block the truth from coming out.
So we're looking at a deposition where Maxwell is being questioned by Sigrid McCauley, who is one of the victim's lawyers, and the entire battleground, the whole fight, is over massage.
It seems so mundane, doesn't it? But massage was the code. It was the key. The plaintiffs argued that massage was the recruitment tool, the bridge from a normal, seemingly innocent interaction to sexual abuse.
And what was Maxwell's defense?
Her defense was to categorize everything, every single interaction, under the broad umbrella of consensual adult sex.
Okay, let's look at this exchange right here. McCauley asks Maxwell, have you ever given Jeffrey Epstein a massage? And before she can even answer, Maxwell's lawyer, Jeffrey Pagliuca, jumps in.
He objects immediately.
He objects. He instructs her not to answer. And he says, to the extent you are asking for information relating to any consensual adult interaction, I'm going to instruct her not to answer because it is her private, confidential information.
Think about the legal strategy there.
Yeah.
It's brilliant in a cynical way. By labeling any physical interaction consensual adult sex, they are trying to wall it off from discovery in a sex trafficking case involving minors.
Right.
They're arguing what two adults do in private is none of your business. But the plaintiffs are arguing, no, this massage technique is the very mechanism by which you groomed and abused minors.
It gets almost absurdly specific. There's a moment here where they're asking about Johanna Stoberg, one of the victims. And Maxwell claims she hired Johanna to answer telephones.
The classic line.
And when she's asked if she ever asked Johanna to rub Epstein's feet, Maxwell says, I believe that I have read that, but I don't have any memory of it.
The classic I don't recall defense.
Yeah.
It's right out of the playbook.
But then McCauley asks the nipple question. I honestly can't believe I'm saying this on a deep dive, but it's in the transcript, and it's critically important. She asks, does Jeffrey like to have his nipples pinched during sexual encounters?
And again, immediately the objection. And Maxwell answers, I'm not talking about anything with consensual adult situation.
So why does this matter? On the surface it sounds salacious, but why fight so hard over nipple pinching?
Because it establishes a pattern of behavior. If you have multiple victims, some of whom have never met each other, and they all testify independently that Epstein had this specific idiosyncratic request during a so-called massage, it corroborates their stories.
It proves they were there.
It proves they were there. It proves they were with him in that intimate context. By blocking the question under the guise of privacy, Maxwell's lawyers were trying to prevent the victims from corroborating each other's testimony and building a credible case.
So when the victims' lawyers in 2025 write to Judge Berman saying, please keep the record sealed to protect our privacy, it's coming from a place of deep, deep trauma. They know how these details, the massages, the specific acts, have been weaponized and scrutinized for years.
Exactly. It's the same legal concept, privacy,
Yeah.
but it's being used for diametrically opposite reasons. In 2016, Maxwell used privacy to hide the crime. In 2025, the victims are using privacy to try and heal from the crime.
Okay, so let's recap where we are. We have the DOJ saying, case closed, no client list. We have the judge saying, the grand jury records stay sealed to protect the process and the victims. It really feels like the walls were closing in on the truth in August 2025. But then,
The subpoena drops.
enter the House Oversight Committee.
The legislative branch kicks down the door.
Yeah, August 25, 2025. The chairman at the time, James Comer, issues a subpoena not to the DOJ, but to the estate of Jeffrey Epstein.
A direct shot at the source.
And if the DOJ memo was this broad, kind of vague, we looked everywhere, the subpoena is a laser-guided missile.
The contrast is absolutely stark. The DOJ memo said, we found no incriminating client list. The House committee responds by saying, forget the adjectives, just send us the documents. And they list these specific items that imply they know exactly what they're looking for.
Let's read down the schedule of requested items. Item number 1. All entries contained within the reported leather-bound book compiled by Miss Ghislaine Maxwell for Mr. Jeffrey Epstein's 50th birthday.
I mean, that is a very, very specific item. A leather-bound book, not a hard drive, not a server log, a physical artifact.
That's incredible. Then there's item 8. All entries from Mr. Jeffrey Epstein's address contact books, one reportedly referred to as a black book from January 1st, 1990 through August 10th, 2019.
Look at that date range, going all the way back to 1990. The scope here is massive. They aren't just looking for the years immediately preceding his arrest. They want the entire 30-year history of the enterprise.
And then we get to item 6. And this is the one that seems to challenge the DOJ's finding directly. The subpoena demands any document or record that could be reasonably construed to be a potential list of clients
There it is.
involved in sex acts, or sex trafficking facilitated by Mr. Jeffrey Epstein.
Reasonably construed. That is the key phrase. That's the counterpunch to the DOJ. The FBI memo said they found no incriminating client list. Congress is saying, we don't care if it's labeled client list in big red letters. Give us anything that looks like a client list. Give us the raw data, and we will decide if it's incriminating.
They also want to follow the money. Item 11 asks for all ledgers of cash payments, digital payments, and cryptocurrency.
Of course. Following the money is usually the most effective way to map a criminal network. If there were clients, they paid. If they paid, there is a record somewhere, unless it was all done in literal sacks of cash.
But here's the one that really stood out to me. It's item 13. They ask for manuals or instruction booklets regarding the maintenance and management of the properties.
The house manuals.
Yeah. 90 71st Street in New York, Zora Ranch in New Mexico, the Paris apartment, Little St. James. Why on earth did they want the house manuals?
Because this goes to the infrastructure of the abuse. Those properties weren't just homes. They were facilities. They were purpose-built for this. If there were instruction manuals for the staff, staff must leave the room at this specific time, cameras must be turned off at this time, guests are to be treated in this specific way.
Wow.
That establishes conspiracy. It shows that the staff, the estate, the entire organization was systematized to facilitate these crimes. It moves it from the actions of one bad apple to an institutionalized trafficking operation.
And the DOJ claims they reviewed all of this. They said they searched the closets. They must have seen these manuals if they exist.
And yet, after seeing them, the DOJ concluded there was no basis to charge any third parties. The House Oversight Committee is essentially saying, we do not trust your judgment on that conclusion. Let us see the manuals for ourselves.
It's a direct challenge. You simply cannot look at the subpoena without seeing it as a massive vote of no confidence in the FBI's investigation and its conclusions.
It absolutely is. And you have to remember the timeline. The DOJ puts out their memo in July saying, we're done, it's over. Less than 60 days later, Congress subpoenas the estate for the very things the DOJ implies don't exist or don't matter. It is a separation of powers battle played out in real time.
So where does this leave us? We've unpacked the sources. We have the DOJ attempting to wipe its hands clean. We have a judge protecting the sanctity of the grand jury and the victims. And we have Congress demanding the physical receipts.
It leaves us in a state of suspended resolution.
Mm.
The legal case against Jeffrey Epstein, the man is closed. He's dead. There's no trial. But the case against the network, the enablers, the clients, the system that allowed over 1,000 victims to be harmed, that is clearly wide open in the eyes of the public and the legislature.
It's so interesting to look at the synthesis of these viewpoints. You have three branches of government, all looking at the same facts, and all defining public interest completely differently.
That is the crux of the entire disagreement. For the DOJ, the public interest means assuring the public that the specific criminal defendant is gone and the threat is neutralized. It's about administrative finality.
Just closing the file.
Closing the file. For the judge, the public interest is about the long-term integrity of the legal system. If you break the seal of the grand jury today just to score a headline, you destroy the ability of all future grand juries to function tomorrow. It's a long-term institutional view.
And for the victims?
For the victims, public interest is secondary to survival. I mean, they want the truth known, of course, but not at the cost of their own safety, their own privacy, their own dignity.
And for Congress, what's their definition?
For Congress, public interest is about accountability, and frankly, it's about political oversight. They are acting as the proxy for the public's deep suspicion. The public looks at the equation 1,000 victims and 0 clients, and the math just doesn't add up. Congress is using its constitutional subpoena power to try and solve that equation.
Let's talk about that math again for a second, because I think that is the thing that sticks with me the most from this entire deep dive. The FBI memo officially confirmed over 1,000 victims.
Over 1,000. Yes.
And yet the very same memo says there was no incriminating client list and no evidence to charge any uncharged third parties.
It presents a logical paradox. You can't really hold both of those ideas in your head at the same time without something breaking.
It's more than a paradox. It's a physical impossibility, isn't it? I mean, trafficking is a verb. It requires a destination. You have 1,000 victims. Who were they victimized with? Who were they trafficked to?
Well, the quiet implication of the DOJ's final finding is that they were all victimized by Epstein alone, or perhaps by Epstein and Maxwell together.
1,000 people. Just the two of them, with no one else involved.
That is the narrative that the official closure of the case relies upon. That Epstein was a singular, monstrous predator with a singular appetite. But the congressional subpoena asking for flight logs, cash ledgers, and house manuals suggests that at least one branch of government believes the operation was far too big, too industrial, to be the work of a lone wolf.
It raises the question, if the client list doesn't exist as a single document, does it exist as a scattered puzzle? You know, a name and a flight log here, a cash payment there, a video entry and a house manual over there.
And that is very likely why Judge Berman was so critical of the DOJ's motion. He essentially told them, you have 100,000 pages of that scattered puzzle. You are sitting on the trove. If you really want transparency, don't try to give us a 70-page transcript of an agent talking. Give us the actual puzzle pieces.
But the DOJ's official position was no further disclosure is warranted.
Which means the puzzle remains in the box, locked away in a government evidence room.
It's so frustrating. You read these documents and you just feel the weight of the bureaucracy sitting on top of the truth.
Bureaucracy is designed to be heavy. It's designed to be slow. But what is so unique here is that the bureaucracy is fighting itself. You usually see the government presenting a united front to the public. Here, the DOJ, the judiciary, and the House are all pointing in completely different directions.
And caught in the middle of that three-way tug of war are those 1,000 people.
Exactly. And that is why the Maxwell deposition flashback was so important for us to include. It reminds us that this isn't just about paperwork and legal theories. It's about real people who were recruited, told they were giving massages, and then trapped in an absolute nightmare. When we debate unsealing documents, we are debating the public release of the details of their trauma.
So what happens next? The subpoena had a return date of September 8, 2025.
We don't have the outcome of that in this particular stack of documents, but we know the battle lines are drawn. The estate has to decide whether to comply with Congress or fight the subpoena. The DOJ has to decide if they will intervene to block the congressional subpoena, citing their own closed investigation. It's a constitutional showdown waiting to happen.
It really feels like the summer of 2025 wasn't the end of the story at all. It was just the start of a new messier phase, the post-Epstein phase, where the fight isn't about him anymore, it's about the secrets he left behind.
The man is gone. The infrastructure of his secrets is still being dismantled brick by brick, subpoena by subpoena.
Before we wrap up, I want to leave you, the listener, with one final thought, a provocative thought, if you will.
Go for it.
The FBI confirmed 1,000 victims in that final memo. 1,000. If there is no client list and no third-party evidence as they claim, who exactly were those 1,000 victims trafficked to? Did Jeffrey Epstein abuse 1,000 girls personally, or is the definition of trafficking being used in a way that hides the demand side of the equation?
That is the ultimate unanswered question, isn't it? It's basic economics, supply and demand. We have officially found and confirmed the supply over 1,000 victims. The government claims they cannot find the demand.
And until that demand is identified, can you really call the case closed?
Legally, perhaps, the DOJ can put a stamp on a file. But morally, in the court of public opinion, certainly not.
That's it for this deep dive. As always, we are just the reporters of the source material provided. We've walked you through the memo, the court order, the subpoena, and the transcripts, the conclusions you draw from here. Well, those are up to you.
Keep reading.
Thanks for listening. We'll catch you on the next one.